Our topic of discussion today is origin, development and application of public interest litigation in India. Before I start discussing, let me refer to the preamble to the Constitution of India. It states that we the people of India, having solemnly resolved to constitute India into a social, sovereign, secular, democratic republic and to secure to all its citizens justice, social, political and economical, liberty of thought, expression, belief, faith and worship, equality of status and of opportunity. I stop here. We the people of India then enacted, adopted and given to ourselves this constitution. Now the preamble actually sets the aims and objectives of the constitution which are to be accomplished in future. It also sets the ideals and aspirations of the nations to be realized. This is the significance of preamble to the Constitution of India. Now I focus on this we the people of India purely from a judicial process, from the perspective of the judiciary. Now when we talk about we the people of India and different types of justices, social justice, political justice, economic justice and equality of status and of opportunity. Now there are large sections in the society who are disadvantaged and they are disadvantaged on different reasons. Social reasons, social backwardness, educational backwardness, cultural backwardness, economic backwardness, even they are not even politically aware, politically active. So because of that their backwardness or they are disadvantaged for different reasons, they are not in a position to ascertain their right. They are not in a position to ascertain their legal and constitutional rights. Even their rights are constantly being violated. Even their legal and constitutional rights are not protected, are not safeguarded. They are showing an indifferent attitude. They are not coming forward for the realization of their rights. They are not coming forward to enforce their rights through judicial process. Now point is that a nation cannot, if this is the situation, and then these large sections of the society who are disadvantaged, they cannot feel that they are also included within the term we the people of India. They cannot link themselves with the we the people of India. They cannot feel that they are integral part to we the people of India which have given, adopt and enact this constitution, fundamental rule of governance of the country, for the socio-economic development of the country, of the people. Now, unless they feel it, so Constitution of India and then everything would be meaningless to them. So this connection, this linking and their feeling is very important. Now our nation cannot march forward unless its people, they are not ascertaining their rights, they cannot enforce their legal and constitutional rights, their basic human rights, some of them are inalienable in nature. And a nation also cannot march forward if its people are not committed to discharging their duty, their fundamental duty to the nation and to the society. Now in this particular situation, so it cannot be ideal situation for a nation. A nation progress would come to a standstill. Now in this particular situation, the Supreme Court, the higher judiciary, High Court and Supreme Court cannot do anything, cannot come forward for the realization, for the protection of their rights because of the common law doctrine, the constitutional jurisprudence where the rule of lucus standi is one of the basic rules to be followed. So judiciary cannot do because of that rule of lucus standi. Secondly, any organization working for the socio-economic betterment of the people of the country, for their economic advancement, for the social advancement. So any organization or any public spirited person cannot do because of the same rule of lucus standi. So let me explain what is Lucus standi. Lucus standi means legal standing. So simply it said that if my legal right, if my fundamental right, other constitutionally guaranteed rights, if these rights are violated, so if I am the victim of that, if my right is violated, I have the right to file the writ petition for the enforcement and for the realization of the rights. Nobody can do it. So because of that, Supreme Court also cannot do it on its own, and any organization working for these people or any public spirited person, even if feeling that something should be done, but because of the rule of Lucus standi, this rule is preventing them from working on behalf of them and setting the tone, even activating the judiciary so that their fundamental rights, their legal rights, their inalienable rights, their human rights are protected. Now, here lies the significance of public interest litigation. Now, simply it means that by relaxing the rule of Lucus standi, a new concept was developed. It was participatory standing. Here, for these people who are disadvantaged, like they, for example, they don't have money to engage lawyer, they don't have money to bear the litigation expenses. That is the reason they are not enforcing the right, or even they don't have time to spend time for realization of the rights, knocking at the door of the judiciary. And because of the reason, if they do it, so they would be losing their job, they would be losing their livelihood, weeks, months, years. Who will take care of their family? Who would ensure the 2 square meals in a day? So that is because of economic backwardness, they are not coming forward for the enforcement of their rights. People are not aware, they are not conscious. What are the rights? What are the constitutionally guaranteed rights? What are the human rights? What are the fundamental rights? They are not aware of it. So this question does not arise. When their rights are violated, they don't have any feeling. They take it as accepted. Now, there are other reasons also. So even if they are aware, but because of their backwardness, social backwardness, cultural backwardness, educational backwardness, economic backwardness, so they cannot, so in that situation, they cannot fight against social elites. They cannot fight against mighty state. They cannot fight the political elites. They cannot fight the economic elites. So here judiciary has come up with a very good dynamic concept, public interest litigation, where judiciary also suo motu can set the judicial process in motion so that their rights are respected, their rights are protected. Any person or any organization on behalf of those disadvantaged sections of the society can file the writ petition for the enforcement and for the realization of their fundamental rights. Now, even in my previous lecture, I mentioned that there were 3 epoch-making judgments in the previous century. Real epoch-making judgments. One was the Maneka Gandhi versus Union of India, where Supreme Court had given a new dimension to meaning of right to life and personal liberty and the meaning of procedure established by law. Secondly, Keshavananda Bharati versus State of Kerala, where Supreme Court says that there are some basic structures of the constitution like secularism, separation of powers, democracy, judicial review, independence of judiciary. These are the basic structures of the constitution which cannot be damaged or destroyed. One second epoch-making judgment. And third epoch-making judgment was the development of public interest litigation. So this public interest litigation has changed the whole scenario, where, like, take for example our MOOC course. So we are giving the classroom experience at the doorstep of the large sections of the society, and to reach out those sections. So same thing, where people cannot come forward to the judiciary for the enforcement of the rights. Here judiciary is going down at the doorsteps of the people for the realization of the rights. Now I would be highlighting the origin, where the concept of public interest litigation was originated. Now there is a report of the Expert Committee on Legal Aid, and report of the Expert Committee on Legal Aid, Procedural Justice to the People. It was May 1973, and this expert committee was presided by Justice noted jurist Justice V.R. Krishna Iyer. So, this committee suggested public interest litigation, administrative side. And secondly, again in August 1977, there is a report on national judicare, equal justice, social justice. It was a two-member committee, two noted jurists, Justice V.R. Krishna Iyer and Justice P.N. Bhagavati. So, this report also suggested and included a draft legislation for legal services and referred to social action litigation, that is a synonym for public interest litigation. And then it is said that the seed of public interest litigation, it was done in Mumbai Kamgar Sabha versus Messrs. Abdul Bhai Faizullah Bhai. It was against this Mumbai Kamgar Sabha, it was a workers' union. This workers' union filed the case on behalf of the workmen because of there was some dispute and payment was due, payment was not being made. And it was against a public enterprise, a business house, not against the state or its instrumentality. Here, Justice V.R. Krishna Iyer, his observation, he accepted this. And the concept and the contention was that this Mumbai Kamgar Sabha did not have any lucus standi to fight this legal case on behalf of the employees. Now, according to Justice V.R. Krishna Iyer, he ruled in favor of Mumbai Kamgar Sabha, in favor of the demands of the employees working over there. I read out two important lines. Procedural prescriptions are handmaids, not mistresses of justice, and failure of fair play is the spirit in which courts must view processual deviances. Second, test litigations, forms of legal proceedings, representative actions, pro bono publico, and like broadened forms of legal proceedings are in keeping with the current accent on justice to the common man and a necessary disincentive to those who wish to bypass the real issues on the merits by suspect reliance on peripheral procedural shortcomings. So, this Mumbai Kamgar Sabha versus Messrs. Abdul Bhai Faizal Bhai said that the germination of the concept of public interest litigation in India, in the soil of Indian judiciary. Next is unofficially a first public interest litigation case. The term public interest litigation was not mentioned there, was not pointed out there, but it says that the judgment is a case where the concept of public interest litigation first had shown its leaves and sprouts were coming out, but it is unofficially the first public interest litigation case. Here, there were thousands of under trial prisoners who are languishing in jails for years, for decades. And on behalf of those under trial prisoners, one lawyer, he filed this writ petition. It was for the writ of habeas corpus. Husainera Khatun was one of the persons who was in jail. Now, point is that their trials were not started even. Had they punished for those alleged offences, had it been proved, their punishment, imprisonment could have been much later. Like 1 year, 6 months, 2 years, 3 years, 4 years. But even trial was not started. They were put in jail for 5 years, 6 years, 10 years, more than 10 years. So, their human rights, fundamental rights were violated. So, this is the case where Supreme Court accepted this writ petition on behalf of others, filed by a lawyer. So, according to Supreme Court, in this judgment, the concept of lucus standi was relaxed, and court says the law is regarded by them as something mysterious and forbidding, always taking something away from them, and not as a positive and constructive social device for changing the social economic order and improving their life conditions by conferring rights and benefits to them. Today, unfortunately, in our country, the poor are priced out of the judicial system, with the result that they are losing faith in the capacity of our legal system to bring about changes in their life conditions and to deliver justice to them. The poor in their contract with the legal system have always been on the wrong side of the law. They have always come across law for the poor rather than law of the poor. In the Golden Book, this Hussainara Khatun versus Home Secretary State of Bihar would be written. Now, Supreme Court says that those under-trial prisoners, their right to life and personal liberty were violated, and what Article 21 says, no one shall be deprived of his life or personal liberty except according to the procedure established by law. Supreme Court says that this kind of procedure, and they are not getting any chance to take part in the judicial process, to get their grievances redressed, to get their rights protected by judicial means, this is not a procedure at all. So Supreme Court says any procedure prescribed by law for depriving a person of his liberty cannot be reasonable, fair or just unless that procedure ensures a speedy trial for determination of the guilt of such person. So this is now officially two judgments which are known as the first official cases of public interest litigation. S.P. Gupta versus President of India. S.P. Gupta, lawyer, he filed a writ petition that about the transfer of judges. This case is also known as first the appointment and transfer of judges case. Now here Supreme Court has very brilliantly, Justice P.N. Bhagavati has brilliantly defined the concept of public interest litigation and what are the grounds, what are the situations when public interest litigation can be filed and who can file. So please, I need to read out this definition given by Supreme Court, delivered by Justice P.N. Bhagavati. Where a legal wrong or legal injury is caused to a person or to a determinate class of persons by reason of violation of any constitutional or legal right, or any burden is imposed in contravention of any constitutional or legal provision, or without authority of law, or any such legal wrong or legal injury or illegal burden is threatened, and such person or determinate class of persons is by reason of poverty, helplessness, or disability, or socially or economically disadvantaged position, unable to approach the court for relief, any member of the public can maintain an application for an appropriate direction, order or writ in the High Court under Article 226, and in case of breach of any fundamental right of such person or determinate class of persons in this court, means Supreme Court, under Article 32, seeking judicial redress for the legal wrong or injury caused to such person or determinate class of persons. Second point, another judgment delivered in the same year, it is the Fertilizer Corporation Kamgar Union versus Union of India, where noted jurist V.R. Krishna Iyer had given a concurring view. It's others. Now, the 3 points which he has raised about the public interest litigation is very vital to important to understand the nature and scope and its significance of public interest litigation. He says, Lucas standi must be liberalized to meet the challenges of the times. Ubi just ibi remedium must be enlarged to embrace all interests of public-minded citizens or organizations with serious concern for conservation of public resources and the direction and correction of public power so as to promote justice in its true facets. An officious busybody picking up a stray dispute or idle peddler or blackmail litigation through abuse of process of the court cannot be permitted to pollute the court instrumentality for private objectives. Public justice is always and only at the service of public good, never the servant or janitor of private interest or personal motive. First time Supreme Court has clearly says that there is a difference between public interest litigation and private interest litigation. So for private motive, for political motive, social motive, for individual motive, personal interest, no public interest litigation can be filed, cannot be accepted. Lastly, according to Justice V.R. Krishna Iyer, public interest litigation is part of the process of participate justice, and standing in civil litigation of that pattern must have have liberal reception at the judicial doorsteps. Next case about, now I will be giving you very briefly some of the examples of public interest litigation. Here Paramananda Katara versus Union of India. What was the rule? That if somebody is injured for one reason or the other, bleeding profusely, going to die unless treatment is started, if that person is brought to a nursing home or hospital, first doctors will not start treating that person, injured person. Critically injured person, they will wait for the police to come and complete the process. After that they will start the treatment. By the time the person might be dying. Here a scooterist was made an accident, and when he was brought to a nursing home nearby Ruby Hospital, very close to EMRC center. So, and then the doctors did not start the treatment. They were waiting for the police, and police came later on by the time the scooterist died. So the newspaper reading that law allows an injured person to die. So with that caption, with that news report, Paramananda Katara, a public spirited person, filed a writ petition before a Supreme Court. Supreme Court accepted this as public interest litigation and says that after that there is a change of the rule. Even an injured person, injured in any way, if he is brought to a nursing home or private hospital or government hospital, health center, primary duty, first and foremost duty of the doctors and nurses to start the treatment. Procedural matters, what is to be done by the police would be completed later on. For police report, for police the process to be done by the police. For that reason, doctors will not stop treating that. It's not that they will not start. They have to start. So this is the judgment given in Paramananda Katara versus Union of India. Now, there are some of the, as I was talking about, some of the guidelines. A full court of the Supreme Court on 1st December 1988. So these are the points where public interest litigation can be filed. 2-3 points I will be just reading out. It says, no petition involving individual personal matter shall be entertained as a public interest litigation matter except as indicated hereinafter. So here you will find out 9-10 points. First one is that here later petitions falling under the following categories alone will ordinarily be entertained as PIL. What are the grounds? Bonded labor matters, neglected children, non-payment of minimum wages to workers and exploitation of casual workers, and complaints of violation of labor laws. Petitions from jails complaining of harassment for premature release and seeking release after having completed 14 years in jail, death in jail, transfer release of personal bond, speedy trial as fundamental right. Person against police for refusing register a case, harassment by police and death in police custody. So these are the grounds where public interest litigation can be filed. Supreme Court will accept, High Court will accept. And these are the grounds where public interest litigation is not allowed. According to that full court decision, 1st December 1988, it says, cases following under the following categories will not be entertained as public interest: land tenant matters, service matter and those pertaining to pension and gratuity, complaints against central state government, admission to medical and other educational institutions, petition for early hearing of cases. So these are the grounds where public interest litigation cannot be accepted. Now I will be telling you very briefly some of the application of public interest litigation. Human rights. This is one category. A very famous case, Dilip Kumar Basu, D.K. Basu versus State of West Bengal. So he filed a public interest litigation, repeated instances of custodial deaths in West Bengal. So that was the reason, and Supreme Court had issued guidelines. It says police is no doubt under a legal duty and has a legitimate right to arrest a criminal and to interrogate him or her during the investigation of an offence. But the law does not permit to use third-degree methods of torture of the accused in custody during interrogation or investigation with a view to solve the problem. End cannot justify the means. End cannot justify the means. So from this judgment, D.K. Basu versus State of West Bengal, we have got some guidelines framed up by the Supreme Court to stop this kind of the custodial deaths in all over India, in all the custody, either police custody or judicial custody. Then judiciary, another interesting point. where I referred that SP Gupta versus Union of India, it was a public interest litigation case. Supreme Court says that, so it was about appointment and transfer of the judges. So here it says that President in consultation with the judiciary will appoint the judges of the Supreme Court, High Court, transfer the judges. So Supreme Court says that in the first case that the consultation does not mean concurrence. So here, even if the judiciary has not given concurrence or consent, so the executive can appoint and can transfer the judges. Later on, it was overruled by another case that is known as Second Judges Appointment and Transfer case. It is Supreme Court Advocates on Record Association versus Union of India, where a larger constitution bench overruled previous SP Gupta versus Union of India by saying that consultation means that primacy to be given to the Supreme Court, and there would be and Supreme Court's view would be reflected, would be conveyed through a collegium system, and what the decision of the Supreme Court conveyed through collegium system, that is to be accepted. So consultation means primacy to be given. So now previously executive had more power to appoint the judges, to transfer the judges. Now judiciary has got more or less absolute power in transferring and appointing judges. Later on, third judges appointment case, it was the President of India referred this matter to seek Supreme Court's view about the appointment and transfer of judges. It was not a public interest litigation, but this larger constitution bench reiterated that collegium system for the appointment and transfer of judges, which was decided, which was announced by a by Supreme Court in response to a public interest litigation filed by Supreme Court Advocates on Record Association. Finally, in the fourth Judges Appointment and Transfer cases, that is a National Judicial Service Commission Act, where Supreme Court again had struck down National Judicial Commission Services Act and saying that it interferes with independence of judiciary, supremacy of the judiciary, and it is unconstitutional, and upheld the collegium system by saying that consultation means primacy to be given to the judiciary. My personal view is that consultation, it's not that only it is tilting towards the executives, neither it is tilting towards it is not that it is primacy has been given to the judiciary. There has to be a balance. No one would get the primacy. These two interpreted. Previously, it was also not acceptable to be. Second, this primacy is to be given. This is also not acceptable to be. Even there must be a balance. Consultation means where both the stakeholders who are the appointing authorities, both will get weightage. No one will get the preference. No one will get the primacy. That is my personal view. Third point, that is again environment. A plethora of judgments about for the protection of environment, for the preservation of environment, to maintain a kind of ecological balance. Because if pollution is if environment is polluted, if environment is degraded, if there is no if ecology is disbalanced, two things: we would not be in a position to live a healthy life, and we would not be in a position to live a life at all. So Supreme Court says, Vellore Citizens Forum versus Union of India, public interest litigation case, where it is said that precautionary principle for the protection of environment, the precautionary principle was developed in this particular case. A famous case, MC Mehta versus Union of India, where development of absolute liability principle was developed for the protection of environment. Then oleum gas leak case, then Ganga tanneries case, so on and so forth. Third one is Rural Litigation and Entitlement Kendra versus State of Uttar Pradesh, where tanneries, the limestone quarries were going on, and it was disturbing the ecological balance in that particular hilly region. So seismic balance was to be destroyed, was to be disbalanced. So here Supreme Court accepted this as public interest litigation and developed the doctrine of sustainable development. Means that all the natural resources are not to be used in such a way so that the future generations, even after 1000 years, they also have the right over it. So we should preserve the environment, ecological, all other resources for the coming generations. There should be a balance between development and right to environment. Last one, Subhash Kumar versus State of Bihar, where the right to environment is a fundamental right under Article 21. Right to get clean water, right to get clean air. These are facets of right to environment, and these are part of right to life and personal liberty. So all the five. There are many other Supreme Court judgments, public interest litigation cases for the protection of environment. I have mentioned these five. Next is women's dignity, a very important thing. Women are not safe in workplaces, and women were traumatized, and they were tolerating. They were not opening their mouth. They would be losing. They would be fearing. They would be losing their jobs. They were apprehensive that they would not be promoted. So, to stop this kind of sexual harassment of women at workplace, Vishakha NGO working for the women filed a public interest litigation. And it is known as Vishakha versus State of Rajasthan, and under article one article of the Constitution which gives power to the Supreme Court to do complete justice. If there is no law, Supreme Court can frame up guidelines. So Supreme Court has framed up guidelines to stop this kind of this kind of practice which impairs the dignity of the women, where women's safety and security are disturbed. So, and this is also not only dignity, it is also liberty also. So according to Supreme Court in this public interest litigation case, it says the gender equality includes protection from sexual harassment and right to work with dignity, which is a universally recognized basic human right. Second point, according to Supreme Court, equality in employment can be seriously impaired when women are subjected to gender-specific violence, such as sexual harassment in workplace. Third one, sexual harassment includes such unwelcome sexually determined behavior as physical contacts and advanced sexually colored remarks showing pornography and sexual demands, whether by words or by actions. Such conduct can be humiliating and may constitute a health and safety problem. It is discriminatory when the woman has reasonable grounds to believe that her objection would disadvantage her in connection with her employment, which includes promotion also. Child protection. Lakshmikant Pandey versus Union of India. Here, in the name of intra-country adoption, the children were sold out. Children were being trafficked. Their organs were sold out. Lungs, kidney, other organs. So to stop this kind of abuse and misuse of children in India, which was going on in the name of inter-country adoption, Lakshmikant Pandey filed a public interest litigation. Supreme Court has framed up guidelines that what would be the rules and regulations for the inter-country adoption. So Supreme Court says, we hope and trust that the clarifications given by us will go a long way towards reducing the delay in procedure to be followed in giving a child in adoption to a foreigner, and will also at the same time protect and safeguard the interest of the child by preventing any possibility of abuse. So in the name of adoption, foreigners, they were taking Indian children, they are adopting, but they were physically abusing, physically exploiting. They were even selling their organs and even killing these children at a certain stage of life. Bandhua Mukti Morcha. So it is a bonded labor case. So there were many bonded laborers working in different areas, including limestone quarries. So bonded labor means that their previous generations, their parents were also laborers working in the same business house, in the factory. Their grandparents also worked, and their children also would be doing the same. So it is a kind of generation after generation. They cannot switch over to other jobs. They cannot leave their job. So to stop this kind of bonded labor, once a labor, and all coming generations would be laborers working for that particular business house, particular family. So to stop this kind of thing, Bandhua Mukti Morcha filed a writ petition, and Supreme Court also has constituted a committee and given some guidelines, and many bonded laborers were rescued and were rehabilitated. Now, the another important point for referring to the judgment Bandhua Mukti Morcha versus Union of India, it says that, as I discussed about, as our legal system is borrowed from UK. So it is a borrowed legal system which is based on accusatorial system. In criminal matters it is adversarial system. So this is not this is not based on the classical India's jurisprudence. So classical India jurisprudence talks about the inquisitorial system, that is non-adversarial system, where the people are not fighting amicably. Judiciary is taking a part, the even who has filed the petition also taking the part, even the against whom the petition has been filed, they are also cooperating. Everybody would be in cooperative mood and would come to a conclusion. So this is based on inquisitorial system. So Supreme Court has emphasized this point in Bandhu Mukti Morcha versus Union of India. It says, the ambit and nature of public interest litigation was explained as public interest litigation is not in the nature of adversary litigation, but it is a challenge and opportunity to the government and its officers to make basic human rights meaningful to the deprived and vulnerable sections of the community and to assure them social and economic justice, which is the signature tune of our constitution. Secondly, another renowned jurist, Professor Upendra Bakshi, he himself filed a writ petition for the living condition of some of the girl students who are in hostels and other government shelters. So, in this writ petition, he also emphasized the point non-adversarial system of this public interest litigation, which is purely based on inquisitorial system of classic India's legal jurisprudence. According to Professor Upendra Bakshi, he says, it must be remembered that this is not a litigation of an adversary character undertaken for the purpose of holding the state government or its officers responsible for making reparation, but it is a public interest litigation which involves a collaborative and cooperative effort on the part of the state government and its officers, the lawyers appearing in the case, and the bench for the making human rights meaningful for the weaker sections of the community. I like to conclude my speech with a Sanskrit slok. It is said, Yukti hine bicharetu dharmahani prajayate. It means the bichar, if there is no rationality, so it is dharmahani, negation of dharma. Dharma means righteous conduct. Dharma does not have anything with religion. It is purely a secular concept. So, if these disadvantaged sections of the society, if their concerns are not addressed, if their fundamental rights, if their legal rights are not protected, honored, safeguarded, if they are not in a position to enforce their right, to ascertain their rights, and they are not getting any help from the judiciary, because, so then it is the negation of dharma. It is the negation of righteousness. It is a negation of justice. So public interest litigation will promote this yukti hine bicharetu dharmahani prajayate. It means it would make yukti a bichar with yukti.